Hey everyone, welcome to The Explainer. Today, we're taking on a topic that honestly feels incredibly intimidating to a lot of people, but it's actually designed for everyday folks to navigate. Our goal in this explainer is to completely demystify the Pennsylvania small claims court process. We're going to walk through the exact step-by-step playbook you need to take a dispute from the initial incident all the way to actually collecting your money. And best of all, we're going to show you how to do it without needing to hire a lawyer. Okay, let's dive into this, because this question right here highlights the massive stakes involved. You absolutely have the power to sue for up to $12,000 in Pennsylvania completely on your own. But here is the shocking reality. 75% of personal injury claims fail within the first 30 days. And they don't fail because the person didn't deserve to win. They fail because of procedural missteps, waiting too long, or just losing crucial evidence before the case even gets off the ground. So here is our roadmap to beat those odds. We'll start with an intro to PA small claims, then preparing your case, filing and serving, the hearing itself, judgments and enforcement, and finally, crucial pitfalls and our legal disclaimer. All right, Section 1, Intro to PA Small Claims, Navigating the Basics. So, $12,000. This number is literally the fundamental anchor of the Pennsylvania small claims system. It's the absolute monetary cap for these civil cases. We're talking things like broken contracts, property damage, or unpaid loans. Now, it's super important to note that this $12,000 limit does not include interest and court costs. But if your court claim is for more than $12,000, you either have to waive that extra money just to stay in small claims, or you'll have to file in the higher court of common pleas, which, let's be real, usually requires a lawyer. Now, what's really interesting about this slide is the geographical split in how Pennsylvania handles these courts. In 66 of Pennsylvania's 67 counties, small claims are handled by magisterial district courts. But if you're in Philadelphia County, you're dealing with the Philadelphia Municipal Court. While both have that $12,000 limit for standard contracts and torts, take a look at the bottom row. The Philadelphia Municipal Court actually holds unlimited monetary jurisdiction over landlord-tenant disputes. That is a massive geographic quirk you absolutely need to know if you rent in the city. If you look at the official Philadelphia Municipal Court information pamphlet, it explicitly states that these courts are built for self-represented litigants. But there is a massive limitation you've got to understand here. These are strictly courts of law, not equity. What does that mean? Well, it means a judge can only award you money. They literally cannot order someone to return a specific piece of property to you, and they can't force a landlord or a contractor to perform physical repairs. It's money damages, and that's it. Okay, Section 2, Preparing your court case, Building your foundation. Listen, time is your biggest enemy when you're building a case. Just look at this timeline. At day 0, the incident happens. By day 30, critical evidence, like store security footage, is often automatically overwritten and erased. The law also gives you very strict deadlines known as statutes of limitations. For personal injury or property damage, you generally have exactly 2 years to file. For a written or oral contract dispute, it's 4 years. If you miss these deadlines by even a single day, the courthouse doors are locked to you forever. No exceptions. So the crucial point is understanding when that clock actually starts ticking. Most of the time, it's the day of the incident. But there's a rare exception called the discovery rule. If you suffer a hidden injury, say a surgical instrument left inside you after an operation, or exposure to something toxic, the clock might only start when you reasonably discovered the injury. Also, if a minor is injured, their 2-year clock is paused, or tolled in legal terms, until they turn 18. But remember, these are very strict exceptions. Never just assume they apply without really careful consideration. To build a winning foundation, you really want to use this checklist. First up, print everything. Your contracts, text messages, repair estimates, before and after photos, print it all. Pennsylvania's minor courts still rely really heavily on physical exhibit packets, so bring at least 2 copies to court, one for the judge, one for the other side. Next, practice a really concise, factual 5-minute summary of your case. Try to leave the emotion at the door. Finally, if you need a reluctant witness to testify or hand over documents, you can request a subpoena from the court. Just make sure you do it 10 to 14 days before your hearing so it actually has time to be properly served. Moving on to Section 3, Filing and Serving the Claim, Entering the System. The paperwork for all of this is highly standardized. You have to file a specific civil complaint document, which is Form AOPC 308A, at the correct local court.
The filing fees work on a sliding scale based on exactly how much money you're asking for, but they generally range from $58.25 up to $99.25. Now, here is a really important tip. If you're low income and just can't afford these fees, you can file a petition to proceed in forma pulveris. If the judge approves it, that waives your filing costs entirely. Filing the complaint is honestly only half the battle. The court literally cannot act until the defendant is officially notified, which is a process called service of process. And under Rule 307, the plaintiff can never serve the defendant themselves. It absolutely must go through official channels. First, you can opt for the court to send it via certified mail with a return receipt. If the defendant refuses to sign for it, step 2 is paying a fee to have a county sheriff or a certified constable physically hand-deliver those papers. Finally, a formal return of service is filed with the court to definitively prove the defendant was notified. And here lies a massive procedural trap. You have exactly a 60-day window from the date you file your complaint to successfully serve the defendant. Not only that, but service must be completed at least 10 days before the scheduled hearing. If you fail to get the defendant properly served within these strict timeframes, the judge is legally required to dismiss your complaint right then and there. Section 4. The Small Claims Hearing, Your Day in Court. Now, these courts are designed to be accessible to everyone, but make no mistake, they are still courts of law. Arrive at least 15 minutes early. If you're late, the judge might just dismiss your case on the spot. Keep in mind, there are absolutely no jury trials permitted at this level. The judge decides the whole shebang. When it's your turn, present your printed exhibits in a logical, chronological sequence. Keep your statements calm and strictly factual. Remember, this isn't reality TV. Perry Mason-style theatrics are not going to help you. And while judges are totally used to self-represented people, they are neutral umpires. They're not going to advocate for you or build your case for you. Section 5. Judgments and enforcement steps, or how to actually collect your money. So what happens after the judge rules? Well, both sides have a 30-day window to appeal. If either the winner or the loser is unhappy with the result, they can appeal, which basically transfers the entire case up to the Court of Common Pleas. What happens there is called a de novo review. That's just a Latin term meaning from the new. It means you literally get a totally fresh trial. The new judge gives absolutely zero deference to what the small claims magistrate decided. It's basically as if that first trial never even happened. Now, if those 30 days pass with no appeal and the loser still refuses to pay up, you're going to have to force the issue. At the magisterial district court level, your main legal tool is requesting an order of execution. You pay a fee and you coordinate with a constable or a sheriff. They actually have the legal authority to go to the debtor's home or business, seize tangible personal property. We're talking things like a television, equipment, non-essential goods, and conduct a public constable sale. The proceeds of that sale are then given to you to satisfy the judgment. It's definitely a gritty process, but it's the law. Let's move to and see how this builds into Section 6. Crucial pitfalls and protecting yourself. Here's a huge pitfall regarding who you can actually sue. It's known as the sovereign immunity bar. Basically, you simply cannot sue a Commonwealth party, which includes state government agencies or entities like SEPTA in a magisterial district court or the Philadelphia Municipal Court. The court simply lacks jurisdiction. If you try, your case is going to be instantly thrown out and you will have wasted your filing fees and some incredibly precious time. As we pull all this information together, here is your absolute ultimate takeaway. Time is your enemy. The Pennsylvania small claims system is highly effective for those who are prepared, but it severely punishes procrastination. You have to act decisively to gather evidence while it's fresh, file the exact correct paperwork, ensure proper official service, and beat those hard deadlines. Preparation and speed are absolutely the keys to collecting what you're owed. Now, as a reminder, this explainer is intended for informational purposes only and does not constitute legal advice. Please consult with a qualified attorney for advice specific to your individual situation. So we know that 75% of people fail right out of the gate. The question is, now that you have the playbook, will you let the clock run out on what you are owed, or will you take action today?